as you see, has accomplished what Senator Cousins and Assemblyman Hasty wanted to do, and has more than accomplished it by shifting the weight from assisting a fairness in landlords and tenants to a completely loaded law in favor of the tenants. So we brought this lawsuit basically against the HSTPA. There were 6 lawsuits brought. The 5 other lawsuits all challenged not only the HSTPA, but the ETPA. We believe that if we could go back to the days of ETPA, that we would probably be more than happy to do that. So we limited our lawsuit to the HSTPA. The 5 other lawsuits have all been dismissed at this point in time. Our lawsuit is still pending. We have claimed, of course, that it's a violation of due process, both in terms of regulatory due process and in terms of physical takings due process. Now, those are very finite legal theories, but if you were reading the newspaper today, you saw that in California yesterday, the Supreme Court declared that there was a violation of due process by allowing unions to go on to property without just compensation. We're hopeful that this may portend well when our lawsuit eventually will get to the point of getting to the Supreme Court, if it goes that far. We have claimed, among other things, that the HSTPA violates due process and is an unconstitutional taking in that it does not meet statutory goals. The statutory goals, of course, are to provide safe and affordable housing. The HSTPA, as we have seen, does exactly the opposite. Because of the elimination of vacancies and the elimination of vacancy increases and longevity increases and the limitation on IAIs and MCIs, many landlords are now not re-renting vacant apartments. And so the result is that when an apartment becomes vacant, it either is not fixed up and tenants are not given the ability to reside in safe, affordable housing. And in many cases, the housing is not being made available to them at all.
The HSTPA is subject to essentially 2 types of challenges. There's the head-on challenge, which obviously is the highest sort of risk reward. If you prevail in the head-on challenge that we brought, or that some of the other folks have not prevailed on, you're in a very good, strong position. The second way is the less head-on challenge, but where certain provisions are implemented in a certain way that those decisions on the implementation get challenged. And that's ongoing, and it happens in all kinds of little cases. And I say little sort of pejoratively because sometimes they have a lot of money at stake, but smaller types of cases that are not challenging the entire statute, but one provision or DHCR's interpretation or implementation of one particular provision. And that has had, in at least one respect, one significant respect, some good success. So prior to HSTPA, for those, I think most of you are aware, but for those who aren't, rental overcharge claims were limited to a 4-year look-back period. And that was based on a prior statutory enactment, as well as regulations that were promulgated pursuant to that change to the ETPA a number of years ago. Unfortunately, Part F of the HSTPA, among other changes, created a 6-year statute of limitation of overcharge claims instead of a 4-year, with no limitation on look-back period to determine the legal rent. So what it specifically allowed for was courts to go back and consider anything in the rent history as far back as reasonably necessary to investigate a rent overcharge complaint and determine the legal regulated rent. In its enactment, the HSTPA did apply to cases that were pending in court, and there were a whole bunch of different types of cases that literally got stopped in their tracks, and judges reissued decisions. Cases that had been closed were reopened, all kinds of things like that. So it was a real, shock to the system, where you thought you were going to win a case, and the next thing you knew, you were losing a case. In this regard, it was about a year, well, less than a year later, a series of cases together entitled Regina Metro Co. Versus New York State DHCR were challenging the retroactive application of the Part F that I just described of the HSTPA, and saying it was unconstitutional on due process grounds. In other words, the idea that 4 years becoming 6 years, and under the circumstances where landlords, in reliance upon the 4-year statute of limitations, had disposed of records and taken certain actions, that they were now being judged to put in a position of jeopardy for relying on the law as it was challenged in the Regina case. The Regina case is really significant because it affects almost every ETPA apartment right now, and both cases, but the Regina and the cases that followed Regina point to the fact that there are still some things under the HSTPA which may be subject to challenge, and under the right circumstances, you can get some favorable decisions. But again, those are specific items, and it remains to be seen which of those will find their way to a successful judicial resolution from the perspective of landlords and apartment owners. So